Hello everyone, welcome to PW OnlyIAS English channel. Hope you're all doing great today. We are here with the next chapter of Indian Polity, that is chapter 12, basic structure. Without any further delay, we are moving right into it. This is the Telegram channel where you can get the PDF of this lecture plus any PYQs that you want to send, the answers from 2013 onwards of the subjects PABAT, all the 4 GS and essay. This is the channel where you can send it. This is also the place where you can directly contact me. So please utilize it. Emergence of the basic structure. Now we need to see how this whole thing emerged, because basic structure, you must understand, it is not defined anywhere in the constitution. It is completely a creation of the Indian judiciary. So how did it come about is the next question. So let us trace its history. In the Shankari Prasad case of 1951, Supreme Court ruled power to amend constitution included the power to amend fundamental rights. That is what the decision or judgment was given in the Shankari Prasad case, that parliament can amend even the fundamental rights. What was the context behind the case? The context was to check the validity of the first amendment, which was challenged in the Supreme Court. In that context, Supreme Court had said, no, Parliament can amend fundamental rights. In the Sajjan Singh case, 1964, Constitutional Amendment Act made under Article 368 does not come under the meaning of law in Article 13. Means what? In the Sajjan Singh case, Supreme Court reiterated or repeated the same thing what they had said in Shankari Prasad case, which was Parliament under Article 368 can amend even the fundamental rights, and such amendments will not come under the definition of law under Article 13. Now under Article 13, if you all remember, Article 13 is what? It is basically that provision in the Constitution where judiciary keeps a check on the law or the acts committed or omitted by the legislature and the executive. They just look into whether it is having any validity. So they basically told, no, constitutional amendment will not come over here. We will only look into bills, laws, that's it. We won't look into constitutional amendment because such amendments don't come under the definition of Article 13. This was the ruling. 𝐂𝐿𝐾𝐄𝐿 case, 1967. Constitutional validity of 17th Amendment was challenged, which inserted certain acts in the 9th schedule. Supreme Court ruled that fundamental right has a transcendental and immutable position, and hence Parliament cannot abridge or take away any of these rights. A constitutional amendment is also a law within the meaning of Article 13. So Supreme Court being Supreme Court, now they changed everything. Their stance in 1951, 1964, in 1967, they reversed the whole thing. They said that nothing doing. Fundamental rights are transcendental. Means what? Timeless, immutable. You cannot suppress it. And even a constitutional amendment act will come under the definition of Article 13. So the whole thing changed now. Literally meant don't touch the FR. Parliament, how did they react to it? They reacted to it by passing the 24th Constitutional Amendment in 1971. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. They passed an act itself, literally making it immune from judicial review. That is, even if fundamental right is taken away by the Parliament, it cannot be questioned by the courts. That is what the Parliament did. Did it stop there? No. In the Keshavananda Bharati case, 1973, Supreme Court reversed its stance in the 𝐂𝐿𝐾𝐄𝐿 case and upheld the validity of the 24th Constitutional Amendment. They said it is true. Whatever you did in 24th Constitutional Amendment is correct only. Don't be surprised. Because 24th Constitutional Amendment, we know what was it about? It basically told Parliament can take away any fundamental rights. Supreme Court said, yes, you can. as long as it does not tamper with the basic structure of the Constitution. However, it ruled that constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. Basic structure was born. Basically, they told, yes, you have all the power in the world, but don't touch the basic structure. So one cannot say that they have reversed the stance actually. They have just played with the words very carefully. Getting the picture here? The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in Indira Nehru Gandhi case, 1975. Supreme Court invalidated the provision of the 39th Amendment Act, which kept the election disputes involving the PM and the Speaker of the Lok Sabha outside the jurisdiction of all courts. That is, in the Indira Nehru Gandhi case, under the 39th Amendment Act, what was the provision? Any election disputes involving the Prime Minister and the Speaker of the Lok Sabha, that should be outside the purview of the judiciary. But judicial review is what? A basic feature of the Constitution. How can you keep something completely out of judiciary's ambit? Parliament reacted with the 42nd Amendment Act 1976. No limitation on the constituent power of the Parliament and no amendment can be questioned in any court. Means what? Emergency time period. Full swing. I mean, the peak of power of the Prime Minister at that point of time. So basically they passed a law telling that we can do anything with the Constitution and nobody can question it. That is what it simply meant. Supreme Court invalidated the above provision in the Minerva Mills case of 1980 and again adhered to what? The basic structure doctrine. That is, judicial review is part of the basic structure. You cannot tamper with it. Whatever constituent power is given to you to amend the Constitution, it has limitations. You cannot use those limited power to do things absolutely. That I will do everything. I am the be all and end all. I will decide what is right. That you cannot do. Taking it further forward. In the Vaman Rao case 1980, Supreme Court adhered to the doctrine of basic structure and said it would apply to the judgments after Keshavananda Bharati case. So 1980, once again what? Doctrine of basic structure is being adhered to. And they said that all the judgments that will come after 24th April 1973, the date when the verdict of Keshavananda Bharati case was delivered, after that date, whichever rule, law, act, whatever you are passing, that will be subjected to judicial review. And if it alters the basic structure of the Constitution, it will be considered invalid. Simple. Clear, people? Moving on. What are the elements of the basic structure? Supremacy of the Constitution, sovereign, democratic, and republican nature, secular character, separation of powers between legislature, executive, and judiciary, the federal character, unity and integrity of the nation, welfare state, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between fundamental rights and DPSP. If you observe here, most of the features given here, you will find that they are very similar to the words that you will read it in the preamble. Which are those points? Please put it up in the comment section. Continuing further, principle of equality, free and fair elections, independence of judiciary, limited power of parliament to amend the constitution, effective access to justice, principles or essence underlying fundamental rights, power of the Supreme Court under Article 32, 136, 141 and 142, powers of the High Court under Article 226 and 227. Now, what is Article 136? Special leave by appeal to Supreme Court. Special leave by appeal to Supreme Court. That means I'm fighting a case. Okay. And verdict came. Let us say it is with regard to a property dispute. The verdict came against me. Now the property is going to be taken over by the government, let us say. I can directly go and file a petition in Supreme Court. Where the special leave simply means for now, Supreme Court will, what is it? Stop listening to other petitions and will give my petition a consideration. That is what it simply means. Special leave petition it is. So quickly they will go through the merits of the case and they will be like, okay, there is some merit in the arguments that I have presented. The lower court has given a decision in a very fast and hasty manner. Basically, they can put a halt on the entire proceeding. Temporarily, everything will be halted until further hearing. So the special leave petition is almost like to undo the errors of the lower court. That is what it simply means. Article 141. Law declared by Supreme Court to be binding on all courts. That is, whichever law the Supreme Court will be telling that, okay, this law is binding on all courts. If a certain law is there, it is going to be binding on all courts. That comes under Article 141. And Article 142, enforcement of decrees and orders of Supreme Court. Supreme Court will see to it that whatever decrees and orders it has given, it will be enforced. Article 227, power of superintendence over all courts by the High Court. That is, lower courts under it, the Sessions Court, etc. Whatever is there, the lower courts, the district courts, etc. So, High Court has superintendence over it. Clear, people? With that, we come to an end of our chapter. Very small chapter, people, but yet very, very important. Please go through the cases. It is important. You can even get a direct question in your GS mains paper. All right, people. So, any further suggestions or comments, please put it up in the chat section or you can contact me in my Telegram channel. Take care.